Well, with the start of the school year about a week and a half away, debate is continuing over that new law limiting how school resource officers are able to restrain students involved in an altercation. We told you last week about law enforcement concerns with this, and now the Attorney General is weighing in, but there's still confusion. Lou is here to talk about what people are saying tonight. Hey, Lou.
Hi, Jana. Well, the impression I get talking to various sides of this issue is that this is not a well-written law and likely will be addressed at some point. The question remains is, how does it get interpreted as school begins across the state?
When fights break out in Twin Cities high schools, if there is a school resource officer in the building, law enforcement leaders say you would expect the SRO to restrain the students.
You'd want to de-escalate that, and one of the first ways that you de-escalate it is that you restrain the other individual. Under this new law, the officers cannot do that.
A new law, included as a last-minute amendment in the education policy bill, prohibits the use of the prone restraint and prohibits the use of compressive restraint on the head, neck, and across most of the torso. Imran Ali, General Counsel for the Minnesota Police and Peace Officers Association, says that language is so broad that it would essentially prevent school resource officers from breaking up fights.
So you can't grab somebody and take him and move him or her to the side. Under the law, you can't do that because there is a total prohibition.
Plymouth Police Chief Eric Fadden is worried about his school resource officers wanting to continue doing the important job.
And setting them up for maybe some liability or police officer licensing issues or some excessive force claims when they are trying to use reasonable force.
But after the MPPOA sent out a letter to member officers asking them to evaluate risks associated with the new law to make a choice on whether to participate in school functions, Minnesota Attorney General Keith Ellison followed up by offering a legal opinion to Education Commissioner Willie Jett that says the amendment does not limit the types of reasonable force that may be used by school staff and agents to prevent harm or death. However, law enforcement leaders say that does not clarify other situations that don't present a threat of bodily harm or death, but are clearly violations of state law.
We're really nervous that, the current way this law is written, it really hinders them and sets them up for some trouble potentially down the road.
They also remain upset that the amendment was added to the bill without the opportunity for debate or for stakeholders to offer guidance. But no word yet from any departments on whether they plan to pull school resource officers from area schools.
I received a statement this afternoon from Minnesota Educational Commissioner Willie Jett that says, in part, the opinion by the Attorney General provides helpful clarity to schools, including to school resource officers who are valuable members of our school communities. Now, I get the impression that the language in this law could get another look in the next legislative session, unless a special session is called before that, Jana.
And that's really next steps here. I mean, we're starting school. It is what it is at this point. It seems clear as mud to a lot of people, but not much to do.
Not a lot of clarity today, but it really seems like they're going to have to figure out how to work with it until the law gets a little bit of work, which would be February when the next session begins.
All right. Thanks so much, Lou. Appreciate it.